What is the legal definition of consideration, and what are the four main elements of a legally binding consideration? In this video, we'll discuss the consideration as our third video in our 6-part series that aims to answer the question of what makes a contract legally binding. Make sure to stay until the end of the video to find out the two main types of consideration. If you're new, I'm Zoppi, an English qualified solicitor and the managing director of Zoppi, my law firm, and my goal on YouTube is to make business law easy. Amazing. So what is consideration? Put simply, consideration is something of value. Consideration is something that is given by one party to the other in exchange for something else. So for example, I might give you products or services and you give me money. My products and services are the consideration for your money. Great, so what are the four main elements of a legally binding consideration? The first is benefit and detriment. The benefit must go to you. For example, if I'm the one who's delivering the service to you, there must be a detriment to me. For example, it takes me a lot of time. Second, there must be mutual promises. So for example, I deliver a service to you and in return, you give me money. Third, there must be sufficiency. And that is the test whereby, under the law, would that consideration, that offer for services, be recognized as something of value? So simply the test is this something of value? And fourth and related, is this something of economic value? And typically economic value is evidenced by the fact that someone has actually paid money in return for that consideration, for example, for that service. Before we move on to discussing the two main types of consideration, make sure to subscribe to my channel to continue to receive to the point, practical and pragmatic legal information. Also, if you want professional legal advice or simply a free legal advice call, make sure to reach out. I have my contact details below. Great, so what are the two main types of consideration? First, it's executory, so that means the person that is providing the consideration will do so in the future. So for example, if you pay me today, in the future, say within 7 days, I will deliver a contract to you. The second is executed. So for example, if you buy a product at the supermarket, it immediately becomes yours. But for there to be a legally binding contract, there must also be intention. The parties must intend for there to be a legally binding contract. And that means that even if you have an offer, acceptance, and consideration, if you don't have the intention of being legally bound, then there is no legally binding contract. So to find out about intention, make sure to watch this video right here.